lovies. How are we? Happy Talk Shit Tuesday. I am 12 minutes late and I apologize deeply from my heart. First and foremost, I flew too close to the sun yesterday when I said I knew how to work the desktop, because I've been trying for the last 20 minutes to figure out how to show something and do the double screen so that we could read this article together. I'm lost. I'm unable to do it. And I've tried it 19 different ways, and it's just not doing it how it usually does when I split the screen. So I was panicked and I felt so bad. I was like, oh my gosh. And then on top of it, look at this. Look at this. She's in her late 30s, okay? And she's housing a prepubescent acne, okay? Just living, breathing on us all, okay? So with that being said, I'm going to try it maybe one more time, guys, okay? That I can try to split the screen and get this prepared for us, because this article was everything. Hi, lovies. Okay, so come on, Kim, figure it out. No. Maybe. No, you don't live there. Okay, yeah, okay, it lives here. I know it lives in the computer, and I can see it, but I just can't do anything with it. She's a genius. Okay, now that we've, okay, so I've opened it again. Call IT. Bob, she's got to call IT. Absolutely. Thank you. I appreciate you. Okay, we're going to hide that. And I feel like I'm going to get it. Just, bear with me, because this is big doings, guys. The reason I wanted to meet you today was because after we talked yesterday, I had known that we were going through, we had gone through what Turtle Boy had discussed with the juror, and it was a big deal. And I was thinking more and more about how it was a big deal for the jurors to, and now I'm on a delay. What is happening? Oh gosh, am I frozen too? My connection is unstable. How am I unstable? Okay, I don't know. I am unstable. Okay, we're gonna do that. Hi, lovies. Hi, Miss Shorty. I am unstable. I don't know how to make the connection better. Okay, so when Turtle Boy was talking to the juror, right, and he did that interview, it was an amazing interview, and I was like, oh my gosh, we need to dig into this further. And I thought that the part about the alcohol and the toxicology has been driving me mental, okay? I'm just sitting here like this and I go, punch a proctor. I'm just doing it because I am unwell over the blood alcohol that was taken at Good Samaritan Hospital and that made its way into the court. And I looked up multiple court filings from the Supreme Court of Massachusetts. And I also found an article that was sent to me by one of our best friends from out of town, Melinda Guarani. She sent me an email and she was like, look at this, Kim. And I was like, tippity tap. Okay. I was ready to go. Okay. So we're breathing through it, and we're going to try it one more time. Okay. Okay. I see it. Present. Share it on the screen. Come on, Kim. You can do this. You sure can do it. Share it. Okay. Now that's good. But I'm gone. Now, I'm sure you can see, but now can't see you. Oh no. Okay. Do. Oh. Oh my gosh, it's happening. I think it's happening, guys. I think I'm doing it. Can you to me tell me? Oh no. Where am I? Oh man, I've got to do something with this interwebs. Okay, hold please. Hold please. We're going to fix the internet. I apologize, guys. Okay, focus. Where did the internet live? In this corner. Okay, find a connection. Find your home. You want to give the satellite. Find your way. Okay, here we are. Hello, hi. Do I appear any better? Okay, I don't want to be on a delay. I am so sorry. She's brand new. She's a tiny moron. She's a schmuck with a desktop, and I love you for showing up. Okay, so we're just going to tippity tap and wish for the best. Okay, look at this. We've got Don't Be Hatin' says, LOL, love hearing Nurse Kim talk to herself. Okay, so that's great. I did not put, I turned off the picture, but kept the sound on. Grow. Okay. All right, lovies. Listen, I think we're doing this though. We're up, we're running, we're slightly unwell, but okay, no thank you. I don't want your updates, Frigga. Okay. Oh, look at it's all happening. Okay, so now I've split the screen in half. Babes, it's all happening. Okay, this is good. Listen, all we needed, all right? We're just 19 minutes past our time. Okay, now, so, all right. So now collect your thoughts, Kimberly. All right, so this is what we were upset about or emotionally charged about, was thinking that this toxicology and alcohol was a huge deal to the jurors, right? And the 6 jurors that got all the way up to 9 jurors to vote guilty on manslaughter OUI for Karen Reed, all of these jurors were very upset about alcohol consumption. They were upset about alcohol consumption with the like, I think everybody, but it was very interesting to hear that, because me as a medical professional, guys, I say to myself, that doesn't make sense, right? Like, it does not make sense that this was admissible to court when Karen was not somebody who was being arrested, detained, or even was sent to the hospital, guys, for anything OUI, DUI related, okay? All she was being sent there for was a mental health crisis. And in the Commonwealth of Massachusetts, because I am a registered nurse in the Commonwealth, it is called, we call it a Section 12. And Karen didn't go to the hospital on her own accord. Like, she didn't say, you know, I'm feeling very unsafe right now. I would love to go hang out at Good Samaritan Hospital. No, babes. What happened was she's with Kerry Roberts, and they're on their way back. She's released from the scene. They're probably taking her back home. A phone call is made, and she ends up going back to 34 Fairview, and the police and paramedics, it was Daniel Whitley who end up getting Karen, and they go, you gotta go, lovey, you gotta head on over to Good Samaritan, where ironically, so is Officer John O'Keefe. Okay, so let's talk to each other. Let's feel emotionally connected. Hello, Donna Rocha. Hi, how are ya? She sent a super sticker. Thank you so much, lovey. I appreciate you. And look, and Jen says to me, you are totally right. Thank you, Jen. I love your picture. I can't even handle it. Every time I see it, it makes me happy. Oh, okay. Margaret says, I have been admitted to a psych hospital a few years ago, and I never had blood drawn. Well, we're going to get to that, babe, because what I know is that there are laws in the Commonwealth, and specifically a new law that just got overturned because of this specific situation. Not Karen's, but it was like a very similar that this guy goes to the hospital. It's 2022. He goes to the hospital. He doesn't give an express consent, guys, for them to draw a toxicology, an alcohol or anything else. He does say, hey, draw my labs, because why, guys? When you're at the hospital, the only thing that you're caring about, and that your doctors and your nurses and your medical staff are caring about, is making sure that we're treating you. We're treating you as a human being. And we do not care if you've been drinking. We don't care if you have drugs in your system. We don't care about any of that. All we care about is saving your life. And part of saving your life is drawing labs to determine, if there's infection, etc. Right? So this is interesting. So back to our best friend from out of town, Melinda Guarini. She sends me this email and she goes, Kim, I blacked out, right? I go, oh my God, I'm blacked out now too. And let's get into this. Okay, so Maddie Wags, hi, Lovey. Thank you for coming. I'm so sorry. I'm a moron. She says, you are 1,000,000% right. They took advantage of her. Is right. Yes. Oh, angry feral lass says, amazing job, Nurse Kim. I just found you not too long ago. Thanks so much. I was also in the hospital and never got it done either. Love you. Okay. Now, and let's just say, would this be okay, interesting. Jenna LaCroix says, would this be a HIPAA violation since the police didn't order the blood draw? That's what I'm saying, babes. That's what I'm saying. Like, I'm seeing all sorts of impropriety, and kind of like it's a HIPAA violation on a couple of levels, but it wasn't even the protocol that is used for Mass State Police. Now, that's a bigger question to me. This wasn't drawn in accordance with Mass State Police crime lab draw policy, and then they just extrapolated it back. So here's what I say. Absolutely not. Like, I'm not picking up what you're putting down, and now I'm aggravated. So let's get into this specific article because it just happened. So this is where all the crazy has sparked within me. So in Providence, Rhode Island, police and prosecutor, one more time, police and prosecutors in 2 states scrambled in the early morning hours of Sunday, trying to figure out if they could legally draw blood from a man suspected of drunk driving and killing a 10-year-old boy in a car crash in Plainville. Okay, like, I'm so sorry. This is so sad. Hi, too blessed to be stressed. How can they judge KR for D&D when the cops were D&D, babe? Sing it to the choir. I'm wondering, because the police officers, specifically even Officer John O'Keefe, and God rest his soul, but he was like, hey, babe, you can drive. So I don't think that anybody had an actual concern for Karen's sobriety on January 28th or going into January 29th. And no one at the scene had a problem with Karen. So I'm just saying. Oh, love a Romy with cheese. She says, Romy says, wasn't something about worrying about prescriptions mentioned on the call? Is that why they had her blood drawn? That is interesting. So her mom, yes, her mother and father, there was a concern when they were on the phone with Kerry. Kerry Roberts said on the stand that she goes, hey, make sure that she doesn't have her medication with her. Now, what that medication was, I don't know. You don't know. I would love for the defense to send it to me, because then I could know. But like, even if she didn't, there wasn't an allegation that she took the medication. It was an allegation to make sure she doesn't take the medication. Do you know what I'm saying? So it wasn't like you'd have to see how much of a level was in her body. If it's her own script and she didn't overdose on it, there would be no reason to get that level in the first place, right? Okay. So now we're back to Michael Escolis, 42 of Oxford, was transported after a crash to Rhode Island Hospital in Providence after he said he rear-ended a family of 6. Oh, gosh, killing the little boy and injuring other passengers. Okay, that is heartbreaking. So Escolis told troopers he drank a little while attending the Kenny Chesney concert at Gillette Stadium, but investigators didn't buy his story, saying he appeared drunk and was driving a stolen car, so they wanted to get a blood sample to confirm it. But Escolis, who had been charged with operating under the influence before, refused the attempt from the police and medical professionals to have his blood drawn, and crossing state borders caused a jurisdictional headache for investigators. I asked Escolis if he would consent to the blood draw to be performed by hospital staff. State Trooper Joe Devine wrote, wonder if he's related to Robert Devine, wrote in a police report, Escolis did not consent to a voluntary blood draw and signed a form acknowledging this. Crossing the border for a medical emergency is common in southeastern Massachusetts, as Rhode Island Hospital is the closest level 1 trauma center for severely injured patients. And while Rhode Island law allows medical professionals to forcibly draw blood from patients who are suspected of committing certain violent crimes, Massachusetts does not have a comparable law. Okay. So when Melinda had sent this to me, my head is spinning. So now it's a different circumstance, right? Because this patient is being taken across state lines. Oh, hello, Cord. Hi, Cord. Thank you so much for the super sticker. And hey, Sleuthy Goosey, how are ya? Okay. So, wait, what is Dopey Hayton says? This makes you question even going to a hospital if feeling that way. I know. And I want you to go there, okay? Like, listen, I just want to tell you, as your best friend from out of town, if you are feeling unsafe, right? If you feel like you are not okay and you're having ideation of either, hurting yourself or hurting somebody else, I want you to call 988. I want you to get the help that you deserve, okay? You've done nothing wrong, and we're all here for you. Like, it's just concerning that afterwards. So the hospital, Good Sam, does everything they're supposed to for Karen, okay? But they didn't really do everything that they were supposed to as it relates to caring about Karen's HIPAA rights, in my personal opinion. All right, now, okay. So Anissa says, if they thought, thank you so much, Lovey. She says, if they thought she was suicidal, I would think a blood draw would be triggering to the patient. You are trying to calm this patient. Anissa, incredible. Are you a medical professional? Absolutely. That would seem to be something that you would have to really, really outweigh the risk versus benefit to your patient in that situation. And then, oh, hello, Karen Reed is innocent. I love you too. So legally, look at Mindy, here we go. Legally, that test should not have been admissible. So after I get this from Melinda, I start going down a rabbit hole, babes, because we know I can't help myself. So I'm sitting here and I go, no, I know personally, right, from working in hospital settings and working in short-term care, long-term, I was a baby when I worked long-term care, but like in all the settings I've ever worked, there is no way in heck that we're providing information to the Commonwealth, even if they've subpoenaed it, that is not related to the specific incident. Like, I'm not even getting past, guys, the fact that Karen didn't have a vehicle at 34 Fairview. I want us to think about that for a second. They were in Kerry Roberts' vehicle when they were there at 6 o'clock in the morning. So it wasn't like they saw Karen Reed's Lexus, that they had any inkling that she was the one who was actually driving it. And she is taken for a mental health crisis to the same hospital in which her boyfriend, Boston police officer John O'Keefe, was also transported to that hospital, on his deathbed and dying at that time. And she is in complete breakdown. What I tell you is that anything that she even consented to when she was being evaluated on a Section 12 should not be admissible. Am I losing it, or is this correct? Thank you. See, Kathy, she was in Kerry's car. There is no rationale for this to be admissible in court. And why this is so important to us, guys, and why I think it is so important to the defense is this needs to go all the way up the food chain. This was denied by Judge Cannoni. And I'm going to pull that up if I can. She's going to try. Because we saw okay, so wait a minute. I'm going to stop. I'm removing this, I think. Okay. Hi, guys. It's just me on the big. And now what do I do with this? No, I don't want to do that. Okay. No, I don't know. Okay. All right. What am I doing now? Oh, no, that's not right either. Okay, bear with me, guys. When I'm trying to do more than one thing, this has not been actually done correctly. So, all right, what was I looking for here? Well, am I on the screen? No? Okay, now I'm here. All right, we're going to close that. And then maybe we'll make it bigger. Oh, Lord. All right. Okay, try this one. Just wait for me. I'll get it. Okay. Now this is what I want, but I wanted to find that specific filing. Oh gosh, Kim, get a life. Okay, we're going to search this, and then I'm just going to write Karen because it was in April 2020. I had all of this pulled up, guys. I am so sorry. Karen Reed blood draw. Okay, because there is a lovely man on the Twitter who has all of this information, and he posted this from April. So I want to share this with you because you'll be like, what? All right. So here it is, April 18th. Now, if I can just get this on the screen, we're going to be cooking with gas, babes. Uh-oh, better call Betterow. Yes, I am. If you guys thought I was right, I'm totally calling Mr. Betterow. And I'm going to be like, also, can we get Mr. Yannetti on this? Because you're welcome. Your intern is working. Okay. Share the screen again. Oh, she's trying. She's so trying. No, nobody cares about that. Oh, because I put it into the new screen. Okay, see, that was not smart. All right, we're going to cancel that for 1 second. All right, let's unsplit the screen. And now I'm going to split the screen. Oh, this is too much. This is too much. I need to get a life. Okay, click the icon. Thank you. Thank you, StreamYard. All right, now we're going to present this, and I'm going to try it again one more time. It's coming. Okay, here we go. I got it. I think I got it. Oh, no. Now I'm lost again. Oh, Lord. No, I don't know where I am. Oh, okay. Here we go. Oh, but now I've lost that. Oh, God. Just end me, Kim. Seriously, stop sharing that. Now, oh, okay. What I was trying to do was pull up this photo specifically, and it's just not, I just can't figure out how to do it. Oh, thank you, Donna Rocha. I appreciate you. I'm trying so hard. Okay. I just need to find it. Okay, we're gonna close that and then open it up again, maybe. No, it still won't pull that. Why won't it pull? Oh, I don't know. Oh, now where's StreamYard? Okay, here you are. Here I am. Okay, well, she's letting it be. Okay. Oh, Kathleen. Hi, I'm sorry. Hi, Kathleen. Kim, you never answered my TT DM or email. We may have lost the interview for you. We may have lost an opportunity for you to interview a special guest that you shouted out to talk with. No. What is your email, Kathleen? I'm so sorry. I didn't see the email. Let me get into my emails. Can you tell me what your email is? And then I'm going to look for it. I'm so sorry. Okay. Now, let's do that. Okay. So let me just read to you, because I'm so sorry, guys. We can't do this all night. You're going to be like, hey, listen, broad, we like you, but not that much. Okay. So, no, now where did that go? Oh, Lord. Okay, well, now I can't even find it on the other screen. Okay. This. So it says now comes, this was in April of 2024, okay? Right before trial, because trial started on the 19th. Are you shitting me? It says, now comes the Commonwealth and respectively moves Honorable Court in limine to admit evidence about the defendant's blood draw at Good Samaritan Hospital during the course of her medical treatment and results from blood alcohol serum conversion and retrograde extrapolation to establish the percentage of alcohol in the defendant's blood. The defendant's medical record of the blood test is admissible under general law, blah, 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 right? Records kept by hospitals shall be admissible and shall be admitted by the court in its discretion as evidence in the courts of Commonwealth, so far as records related to the treatment and any medical history of such cases, and the court may, in its discretion, admit copies of such records if certified by the persons in the custody thereof to be true and complete. Okay, that's a lot. All right, so it says that the Commonwealth anticipates that the medical providers who participated in the blood draw will testify to their knowledge, expertise, and training, how the test was administered, to demonstrate their reliable basis and knowledge of the experience. Oh, well, we have a problem, babes. We have a problem, because I'm going to need you to tell me who told us on the stand about a blood draw of Karen Reed. Who sorry, I'm not an owl. I'm who on the stand from Good Sam said that they did a blood draw on Karen Reed? Because I didn't hear it. I didn't hear ER Doc Justin Rice say that. Did you? I didn't hear Dr. Fowler, who is our pathologist, who ran the sample. Absolutely, he ran it. But I don't recall hearing from a nurse. Do you? Oh, thank you, Peek. Thank you. You are a hoot, though. Oh, I love that. The lab guy did testify, Mallory, but he didn't take the sample. And that is what Lally said in his filing the day before the trial started, that there would be that the person who drew the blood would be testifying. Do you recall that person? Because if you do, I'll go back, because, maybe I know that I don't remember everything, but I was just thinking, like, I don't recall that. Kim, oh, Jonathan Rubin. Kim, the Commonwealth's motion was unopposed. Really? Because on Rich Vetstein on X, they said that the defense already opposed this motion last week in court. And he says, yeah. He says, yep, just Lally being Lally. So it wasn't opposed. And no chain. Oh my gosh, that's another thing. Lauren Raz, no chain of custody. Well, here's the deal. So it was technically always just at the hospital. It wasn't like this was like the sample was brought. They just did tests, like they just pretended and extrapolated. So it said that it was 0.9, it was 993 deciliters. And then they did a conversion. They did a and they did it, and they scientifically extrapolated that that would have been like a 0.08 to a 0.09 of a BAC, because it wasn't the proper testing at all. And then they said that it was it would be extrapolated to 0.13 to 0.26 or 0.24 for at the time of the incident at 12:30 a.m. Oh. Oh, absolutely. Mindy, that range was ridiculous. Like that was such a swing that I don't even understand how that could have been presented to the jury either, right? Like if we're thinking about that, guys, like who in their right mind would say, "Oh, okay, so she could have been in theory absolutely smashed face, smashed, or she could have been having alcohol poisoning at that level." I mean, that's literally 3 times the legal limit. And Karen doesn't have meat on her bones like I do. You know what I'm saying? Like I could probably throw him back, but she doesn't have that kind of meat on her bones. Okay. So then we have Rebecca Jones. Oh, I love you, puppy. Regardless if the CW got a warrant for the results, no officer maintained a visual chain of custody. They didn't even do it. And the sample was taken. Nope, I lied. The sample taken, and you need to prove the chain of custody and no tampering or contamination. I absolutely, Rebecca, that is true with the physical samples. And then oh my gosh, I have missed too much. I'm sorry, guys. I am being a test creature tonight. Okay. I apologize. I am not on my game. I was flustered. And then this is what we get. Oh, hi, Jen K. You became a new member. I love and appreciate you. And then we have, who else do we have here? We've got this. Rebecca Jones, you also said law enforcement here in Canada. If I take a person under my authority to a hospital for mental health concerns, nurses take the blood for analysis. It has nothing to do with crimes investigated. Blood warrant would be needed and signed by a judge to give police a permission. That is incredible that you say that, because there are similar. Okay, so each state runs differently, right? We know that even though we are these United States of America, every state is different. And the Commonwealth of Massachusetts is actually what we call an implied consent state, meaning that without your actual like God-given consent, like I say, yes, I allow you, Officer Divine, to take my blood. Don't touch it. Don't touch it. And I have to say, yes, you cannot like pull the wool over my eyes in any way in the Commonwealth. And like I said, there was this new law that just happened in 2022, which I'm sure the defense knows about, but it got overruled by the Supreme Court of the Commonwealth of Massachusetts. And this patient's information that was once allowed in they said, absolutely not, take it out, get rid of it. And that you can't manipulate the law that Lally put in that motion on April 18th. You can't manipulate it to work in the Commonwealth's favor. Okay? That it has to be like taken as is and is not allowed. There can't be like a misbalance or an imbalance of power. You have to have the same rights for the defendant as you do the Commonwealth. And that was not taken into account, in my opinion, in this specific case. Thank you, Rebecca. Okay. Oh, thank you. Thank you. Oh, classic overthinker. Are you kidding me? Are you my soulmate? All right. If I just could get my technology, I got to tell you something, guys. Calm is a bitch. And when Kimberly Jean got on this computer yesterday and was doing our early evening stream, and I thought, and I figured out, and I had things on the screen. I had Turtle Boy's beautiful article, and I was getting random emails, and I was like, look at her. She's a natural. Nope. We've hit a roadblock tonight. Okay. So clip this in. Oh, I love that. Deidre Sargent says her BAC level should have never been part of the trial. Fourth Amendment violation and irrelevant with passage of time, and they cannot backtrack the BAC. Deidre, are you a lawyer? I love that. That was so sassy. And Jenny, I got your number 33. Clip this and send it to Unetti. I will, babe. Okay. Now, focus. Oh, Deidre's LEO. Okay, I love it. And look at your wig on your doggy. I love that. Okay. So here, okay, now I'm going to try. Oh, guys, I'm sorry. This is a real... Here's a positive, though, is that TB said that he is moving his stream because it's the presidential debate. I'm so sorry if I'm holding you from that. If that's what you want to go watch, I totally get it. I just, I would rather do anything but. Okay. So, okay, now I'm going to, ready? Ooh, she's a wild woman. Now try to split it, baby. Okay. Now, here we go. I can do this time. I can feel it. She's getting a rhythm. Okay, share the screen. Find the screen. Share the screen. Here it is. Okay, babes. You're about to black out. Share it. Oh, nope. I lost myself again. Okay. I don't know where it goes. All right, but okay, so it's over there. Uh-oh, now I just have a black screen. Oh, God. Cancel. Can you see me? Oh, no, where am I? Oh, everything's black. Oh, Lord. We've all gone blank. Okay. Oh, Nurse Kim is double timing here. All right. Oh, no. Okay, wait a sec. Oh, you can see me. Oh, okay. Well, that's good. Oh, it's telling me I'm entering the studio. Oh, Lord. Okay. All right. So as long as you add, okay. And then just find this. Okay. Nope, that's not it. Oh, all right. She's okay. I'm going to get rid of this one because I don't need it. But now I can't find, I don't know where I am. Commonwealth. All right, here we go. Black. Okay, we got it. She's got it. All right. Oh, now I'm gone. Oh, now we're actually blacked out. Okay. Can you see me now? I'm coming back. Oh, no. Okay, you can hear me. All right, this is, as long as you can hear me. All right, I just want to put this up. And, well, really, Kimberly, where are you? Where have you gone? Okay, we're going to do this. We're going to get that out of there. And we're going to put this over here. And, okay, now we're going to present and share it. And it should be right here. Okay, share it, baby. Okay, so, all right, guys, now this was a slip. Okay, it's Commonwealth versus Eric. I don't know who Eric is, but we know him somehow. And he says that it was January 5th to to July 29th, 2022. And it says that he was operating under the influence. I pirouetted to Mars, Elena Maria. You know it. Well, I can see you. This is the most wild stuff. I need help. I need an IT professional. Okay. So, the motor vehicle is operating under the influence. Evidence was the blood alcohol test. I found this on justia.org. And it says that the complaint received and sworn into the Gardner Division of the District of Court on October 15th, 2020. And then, oh my gosh, I love you. Look at Kim's going to play hide and go seek. For the love of Christmas, where am I? And I don't even know. The thing is on. Oh, well, wait a minute. Let's try this. Okay, stop the cam. Oh, now, okay. So guys, you see when I'm stopping the cam, that means the American flag is on. That's me. Okay, I usually am the American flag. Then ready? Boom. Where is she? I don't know. I don't know where she is. Okay, but I'll come back. I think I'll find myself. She's on a road. Okay. So he goes, it's a pretrial motion, beep, beepity. We know all of that. Now, okay, here we go. Now we just got to get this and pull it down to say that Cipher. Now, Cipher is a Supreme Court justice. The defendant is Eric J. Moreau, and he had been charged with operation of a motor vehicle while under the influence of alcohol, OUI, with a blood alcohol content, BAC, of 0.8% or greater, in violation with General Law Code, which, babes, just a reminder, that is General Law Code 90, Section 24, 1A, ba-ba-da-bee-ba-ba. Now, babes, reminder, that is what Lally cited as his reason that he was able to collect Karen's blood, okay? That was that was what he cited. Well, I got news for you, Lally boy. I got news for you. Okay. And we know that the defendant filed this interlocutory appeal to challenge the denial of a motion to suppress the results of this test of the defendant's blood BAC conducted by the state police crime lab without the defendant's consent. For the reasons discussed inside, we reverse the denial of the motion to suppress. So they reversing a denial is granting, guys, okay? So the background, we summarize the relevant facts found by the judge, supplemented were appropriate with uncontroverted testimony for the suppression hearing. The relevant facts are undisputed for the purposes of present appeal. On September 29, 2020, a police officer responded to a report of the motor vehicle accident. On arrival at the scene, the officer observed a pickup truck that had collided with a tree off the side of the road, suffering extensive front-end damage. No other vehicle was involved in the collision. The officer spoke with the defendant, who was seated in the driver's seat, and admitted that he was the operator of the vehicle. The officer observed the defendant to be unsteady on his feet, slurring his speech, glassy-eyed, and a strong odor of alcohol emanated from the defendant's person. Well, babes, I'm going to tell you this. We are physically blacked out. Kim is in a blackout right now. She's gone. We don't know. Is she even here? Yes, she is. But I don't know why my little camera doesn't like me. Oh, and it's on. Okay. So listen, this made sense, right? Like, at least if they wanted to get something with Mr. Slurring Speech, glassy-eyed, strong odor of alcohol, bing, ding, 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 you're getting closer, my friend. But you know what you're not doing is you are not, like, you still haven't given your consent, and you have to consent to it. So the defendant was transported to a nearby hospital. The police gave to hospital personnel a preservation of evidence letter seeking the preservation of any blood that might be drawn during the during the medical treatment. The police obtained and executed a search warrant for the defendant's blood. The blood was transported and analyzed by a crime lab for the BAC. Police never requested or obtained the defendant's consent to test his blood for blood alcohol content. High court, thank you. Kim becoming the Where's Waldo of her own live. Hope you find yourself soon. Babe, I've been looking for 38 years, okay? 38 years she's been on the search to who's Kim? Who the heck are you? And she's lost herself tonight. Oh my God, I love you. That's hilarious. Okay. So right. So they're like, oh yeah, we're seeking this evidence because we want all your jazz. Because why? That's what the police always want. Okay. Then the police obtained the search warrant for, okay. It was okay. And then the police obtained and executed a search warrant for the defendant's blood. The blood was transported and analyzed by the crime lab for a BAC. The police never requested or obtained the consent. Now, the defendant was charged with an OUI in violation of negligent operation of a motor vehicle. The defendant moved to suppress the results conducted by the crime lab, arguing that he did not give consent. The judge denied the motion in an evidentiary hearing. The defendant filed application for leave to file the interlocutory appeal, and a single justice of this court allowed the application and ordered the appeal be proceeded to the Supreme Judicial Court. The sole issue on the appeal is whether, pursuant to blah, 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 a BAC test is done by or at the direction of police without the defendant's consent is inadmissible in a prosecution for an OUI pursuant to that law, which is General Law 9024, where blood was first drawn independently by a third party. What if any shits are we flipping out right now, guys? Have we lost our collective mind? So you're telling me that where the blood was first drawn independently by a third party, it was inadmissible. I'm obsessed. Okay, thank you. Thank you, Justice. And then they say, as a matter of statutory interpretation, we review the issue, de novo. And it says the meaning of a statute must first, in the instance, be brought to the language in the, okay, we're getting real into law talk right now, which I am not. Mr. Betterow, I need you. Okay. And then we find out it is additionally a basic tenet of the statutory construction that requires, oh no, we're still superfluous. I can't. So, okay, here we go. Section 24 provides the conditions under which evidence of the percentage by weight of alcohol in the defendant's blood at the time of the alleged offense, as shown by chemical test or analysis of his blood, shall be admissible in prosecutions for operating motor vehicle while under the influence alcohol pursuant to. But they're saying that in any prosecution for a violation, and although it's not implicated in a case such as this, where the statutory requirements are unmet, we note there were conditions of Section 24 that are met, but the BAC evidence is only presumptively admissible in a prosecution, only presumptive if partial. Okay. I'm pack it up. Okay. So the requirements, right, must meet general requirements that exist separate and apart from Rule 24, such as laying the proper foundation and complying with the defendant's constitutional requirements. Okay. So admissibility of the BAC evidence in the prosecution for OUI is the defendant must consent to chemical test or analysis of his blood drawn when such an analysis is made or at the direction of a police officer. Our interpretation of this provision is controlled by our decision in Boyenham, and that's like case law. So now this includes, wait a minute. So back it up, woman. The court also concluded that the testing of the BAC and the drawing of the blood, of course, a blood draw is a prerequisite to a chemical test or analysis, but it requires a blood sample to be tested and analyzed. Therefore, separate from discussion of safety concerns surrounding the blood draw, the court's conclusion is that the test and analysis of the blood includes preceding the blood draw, such as a police must obtain the defendant's consent to such a draw is correct for this reason. Okay, now let me break that down for you guys, okay? Because I think we are all potentially blacked out. Literally, we're black squaring on a screen. But what we're trying to say here is that Karen, although she said, yes, I accept that I would like to have this, whatever. She accepted the blood draw and the treatment at the hospital. That had nothing to do with anything that had happened at 34 Fairview with her vehicle or anything else. Do you know what I'm saying? And because Karen, you know damn right well, when we're all of us nurses in the chat, or doctors in the chat. If I have a doctor in the chat, how are you? Just like we know that we are taking blood and we are running how many different panels, babes? How many different panels are we doing? We're drawing every tube. Give me a lavender, give me a blue, give me a green. We want them all. And whatever you're like a lipids. We're doing every single thing that the doctor has asked us to draw. Now, if Karen signed a consent to treat, this justice was saying, guys, mark my words, send it to Mr. Alan Jackson and David Yannetti. They're saying that Karen needed to provide expressed consent, that she was consenting to the alcohol test, to the tox screen. And guess what, babes? Even if she did, she was at the hospital for a Section 12. And I do not believe that anything that she said should be admissible in court, because she was hospitalized for a mental health crisis. Okay, that's where I was going with that. Okay. So now, okay. Okay, so now the justice is saying back to us, right? This justice is like, I love this justice. We should start a friggin' fan club. First, such an interpretation would contradict the plain language of the statute, rendering the consent provision of 24 inoperative in certain situations where, according to the plain language of the statute, the consent provision applies. We will not read an exception to the consent provision into the statute's legislator, because we did not see fit to put it there. Second, such a reading of the statute makes sense only if the legislator's sole intent in drafting was to mitigate safety concerns related to non-consensual blood draws. Although such concerns likely were a part of the legislator's motivation in drafting Rule 24.1, we have no direct evidence of such intent, and the plain language of the statute indicates that the legislator was motivated by other concerns as well. And okay, so then, However, if such test or analysis was made by or at a discretion of a police officer, it was only made with consent of the defendant. Because remember, babes, you can only get blood from anybody that is in like an OUI situation in the Commonwealth. Everybody has a right to deny, to refuse. You have a right to refuse. So thus, oh gosh, I know, right? Romy, love a Romy with cheese. We're calling better, Ro. I'm sending him an email. No, I'm going to DM him onto Twitter tonight. Okay, so scoobity beep bop. Listen, babes, if nothing else, your girl is using her legal nurse consultant certification far further than I'm supposed to. I'm not supposed to be reading laws. I'm just supposed to be going over medical records. Okay. So then it says the withdrawal of blood, yes, thus separately discussing the chemical test and analysis. And okay, the interpretation is supported by the second statutory prerequisite of the admissibility of BAC into evidence is that the results of any chemical test or analysis of the defendant's blood may be available to him upon his request, and that the defendant may be afforded every reasonable opportunity at his request and his expense to have another such test or analysis made by a person or a physician selected by them. That's it. That's it. That's it. Guys, we've solved the case. We are actually on the team. Okay. Call us defense counsel, babes, because we are rolling with this one. And then we've got so she was never given any additional information or ability to get another test to say like, hey, I think this was wrong. And then the chemical testing is entirely unrelated to the concerns about preceding blood draw, such as concerns that reasonably cannot be said to arise only if there was a blood draw subsequent to the test and analysis that is done at the discretion of the police. Okay, now give me the final. Read me the verdict. Because we could, the plain language of the statute, yeah. Now just give us what you said. How many pages is this? Okay. Focus. Wait, how do I get rid of you? Oh, Lord. Okay, here we go. Page 18. Okay, so, was it only 18 pages? The police officer who responded to the accident scene observed that the defendant who conceded he was the operator of the pickup truck, that he had collided with a tree, was unsteady on his feet, slurring his speech, glassy-eyed, and that a strong odor of alcohol. Yeah, okay, we knew that. Okay, the officer chose to have the defendant transported to the hospital and did not preclude such action. So, and they didn't. The police officer likely could have placed. Oh God, I missed it. I'm so sorry, guys. Okay, I don't know what I did here. So, okay, they presumably would have provided probable cause that the defendant had violated whatever law, and the police officer likely could have placed the defendant under arrest. That police officer chose to have the defendant transported to the hospital and did not preclude such action. So then they say per like Mass versus Dennis, if the officer had defendant suspected of OUI sent to the hospital and placed the defendant under arrest in the ambulance, that would have been a different situation. Had the officer placed the defendant under arrest, we would have been triggered such that if the defendant refused to consent a BAC test or analysis, his license would have been automatically suspended for a period up to or included 180 days or up to a lifetime of loss. While it is not our role to pass judgment on the legislator's policy decision, it appears that the statutory scheme, babes, okay, for the protection of the public from dangerous offenders. All that is required is that the police follow the procedures set forth by the legislator. Conclusion: for the foregoing reasons, we reverse the denial of the defendant's motion to suppress. So ordered. Can we give it up for Justice? Who is this? Justice. We love this one. Justice Scoobity-Bee-Bo. It is Justice. I don't even know the name. Oh gosh, where are you, Justice? Tell me, Justice. Well, that Justice, I love them. I'm gonna send them a fan mail. Oh, Commonwealth. That was a motion. Yep. Okay, and yeah, this was good. All right, so okay, yeah, we knew that. You need a probable cause and arrest. Is this an appeals court? Oh, okay, OnlyFan. This is law now. Like they made, like this passed. So now it is Commonwealth. Guys, we have to send this to Mr. Yannetti, seriously. It's Commonwealth versus Eric Moreau, Moreau. And like now we have case law, babes, that we need to provide because this, and like not even that, but like furthermore, like they're saying, Karen was never arrested. She was never detained. She was never put in the back for any questioning. Her vehicle was never at 34 Fairview when the police officers were there. And my biggest thing is that Karen Reed was transported to Good Samaritan Hospital for her Section 12. Okay, now I'm going to get rid of that and see, can I come back to life? Show me the meaning. Nope, she's still not here. Okay. Am I over here? No. Okay, I'm going to try to come back up. Ready? Boop. Oh. Okay, no. Stop the camera. Okay, stop the camera. Nope. Okay, she's just not here. Okay, so this is just like huge. And again, I'm so sorry, guys. I do not know where I am or what has happened, but I promise you know I am here. Oh, wait, right. Add to stage. Nope, she's still just a block. We've done something. I have somehow tricked, apparently, StreamYard into thinking I am not here. Okay. Oh no, now you can't hear? Can you hear now? Oh my gosh. Oh Lord, if you can't hear me, I am going to cry. Oh Lord. Cedra. No, not Cedra. Can anybody hear me? Hi, oh gosh, who is she? I need confirmation. I need confirmation of life. Oh, okay, Carrie, thank you. Oh, guys, all right, it's all come. Oh, geez, so you just heard me crying. Okay. Okay, it was not an abduction by Cedra. But guys, isn't that so huge? Like, don't we feel so interesting about this? Like, I feel this is a really big deal. I really do. And I feel like this is something that is going to be so helpful to Misty and Eddie, to Karen Reed. And because if nothing else, guys, here's what we don't want. We never want somebody to have their like civil rights violated, right? Like are you kidding me? And I feel that even though Judge Cannoni shut this down, and I guess I'm kind of getting mixed signals from you guys. I don't know. When I read the April 18th motion or filing that came in from Lally, we also have a serious problem where he said that somebody was going to come and provide all the information about how the test was administered to Karen, and it never happened. It never happened. So this is absolutely insane. We never got that information. We did get the information from from Dr. Fowler, who was the pathology, and he was the lab doctor, but he wasn't the one who drew the sample. So these are all things, and there are so many other kind of circumstantial things that you need to think about, guys, too, which they include like when Karen's last drink was. And I know that everybody wants to say that it was at like 12 o'clock or whenever she was leaving the waterfall. But I firmly believe that Karen could have gone back to the house, could have gone back to, to One Meadows, to John's house, and had a nightcap, or been like, I'm going to knock him right out when he gets his ass home. Oh, he better hope I'm going to leave him these voicemails and he's going to get his ass home soon. Like, I truly believe that she maybe had a drink or two when she got home. And another thing that I feel like it was such a violation was that although Kerry Roberts said that Karen smelt of alcohol, no one that was imperative at the scene or was law enforcement or medical providers, i.e. the EMS, Daniel Whitley, Flamati, Katie McLaughlin, even Timothy Nuttall, Lank, Mulaney, all of them, Saraf, nobody documented that Karen Reed smelled of alcohol. So how is that even possible? How is it possible that we've got Karen facing these consequences when nobody said anything about alcohol related to her on the morning of January 29th, 2022? Oh gosh, Julie, Dr. Justin Rice. And listen, you guys know that I have the most respect for all physicians, right? Like well, not all physicians, but I love physicians. I was living on a prayer, Bibs, that he was going to come through. I said, he's going to document this. It's going to be incredible. Like, I was like, this is all going to work out. Nope. That was embarrassing. It was embarrassing to our profession. It was embarrassing to him, which interestingly enough, you know that he stopped working at Good Sam shortly thereafter. Just saying. But he didn't recall anything. He was making up that, like, he got in report from Flamati that it was a possible vehicle, like a pedestrian strike. There was nothing in Flamati's documentation, and there sure as shit was nothing in Justin Rice's documentation that said anything about a vehicle. So that is something too. Yeah. And I just really would like everybody to have a chance to I want to review that, Julie. Like, if I could, I've asked Misty Yannetti if I could please review all of the medical documentation. He hasn't let me know, but I would really love him to let me review it. And okay, we'll do that. Okay. And then Deirdre says, Kate, that's exactly why there's no formula for backtracking BAC levels. It's disallowed in every other trial I have watched. Experts say there is no such formula that exists. And you know what, babes? That's so interesting that you say that, because I really liked the guy who, and I am so sorry, I can't think of his name right this second, but who completed the extrapolation. But he said that there are so many variables, and that they took on face value what the DA, what Adam Lally told them was the narrative. Nobody ever reached out to Karen Reed to ask her, does this make sense? Do you have any other medications in your system that may affect this? Do you have any medical conditions? Because yes, they did know that she had MS, but I don't know if they knew anything about her GI concerns and her massive history with her gastrointestinal system. And it is such a wide range that I feel like, because that is not to a degree of medical certainty, that there's no way it should have been let in my personal opinion. Okay. And other than that, yeah, I agree, guys. And it says, ask the DUI guy, the lawyer. Okay. I'll reach out to him too, Michelle. Thank you so much. I know. Oh my gosh, hippie chick, I love you. You should be seeing me. If you could see me right now, I'm on another planet. I'm literally extraterrestrial. But I don't know where I went. So that was just what I wanted to talk to you guys about tonight. And I just wanted to read over that information because it's big doings, guys. We need to really understand that, like, we have to fight harder, right? Like, even though Judge Canoni denied she denied to suppress it, we got to send it up the ladder. We got to be like, boom, we're putting it up to the Supreme Court, just like this case did. Or I don't know, I'm going to have to go find the filing, or if anybody has it, can you email it to me? The filing to oppose this, the one to or not to oppose it, to submit, to suppress it from the defense. If you could send it to Nurse Kim at, legal Nurse Kim at Gmail, because then I would love to review that and see what statutes they did and what precedent and law they used, because we'd have more of a leg to stand on if we used this new case. Yes, that's all we can do, Jen. That's all we can do, Jen, is to keep pushing. Okay, lovies, that's it from me. I am all set. I am blacked out with you. I am so sorry. I don't know where I went. Again, I flew too close to the sun and I thought I was doing so well. And I was like, oh yeah, Kim, you got this. You know what you're doing. No, you don't. No, you don't, babe. So I'm going to work on my computer skills. I'm going to be better the next time. And thank you so much for answering my FaceTime that turned into a regular phone call. I can't. Okay. I love you guys so much. I love your face. Have a good night. Bye.